Now we're going to talk about frequently used provisions in a LOI, and we'll start with some frequently used non-binding provisions. First up is purchase price. While the purchase price in an LOI is generally not a non-binding term, it might be, and it might change a little bit during due diligence, it's probably one of the most important terms of your LOI. It can be fixed. It could be based on a formula. It is usually the parties put forth how they're going to pay the purchase price in the LOI. You know, is it going to be all cash up front? Is there going to be a down payment with a promissory note for later? Is it going to be part cash, part stock? Another tool is, you know, that people should consider as a promissory note, or it could, you know, holdback, which we'll talk about later, but a portion could be paid through a promissory note, which can help bridge a gap between, you know, discrepancy, you know, debate about purchase price between the two parties, or it could help the parties allocate risk where a seller needs to sort something out before, can't sort something out before closing and has to do it post-closing, so the buyer will have to, you know, will be able to be assured, you know, taking a little bit less risk. An example of this is, this came up in a deal I closed last year. The sellers knew they would not be able to get all of their landlord consents before closing. They just knew it wasn't going to happen, and so the parties agreed to put some of the purchase price on a contingent promissory note that would be paid later if certain conditions were met. Fortunately, in that situation, it motivated the sellers to really work at it, and we got those seller notes paid off. But it can be a useful tool for situations like that. Related is how the purchase price might be adjusted. A common adjustment tool is net working capital. Net working capital can be a good gauge of a company's short-term ability to cover obligations, and it's typically calculated based on the balance sheet. But agreeing to how it's actually calculated can prove difficult. Often you'll see in LOIs a shorthand of, you know, as mutually agreed, or it'll be calculated based on past practice, or some shorthand like that, and that can lead to problems later. Now, you might not be able to agree to it up front, but having more detail about it in the LOI can save you some headaches later. And network capital is a moving target, so the parties will need to come up with a target capital for closing, and then we'll actually need some time to true it up. It could be 30, 60, 90 days, and you know, some of the nuances there are, you know, seasonality, accounts receivable of the company, you know, their typical collection time. So it could, you know, drastically change, and the parties need to true it up after. The true up could be a dollar for dollar adjustment, or it could be, if it's above or below a certain dollar amount, more or less, the purchase price would then be adjusted. Then I have a couple of examples. These are just examples of how you might see it in an LOI. This first example shows that you know, the net working capital will exclude cash and debt, so that's a little bit of detail, and that the target will be calculated based on historical average and will be mutually agreed. Again, these are shorthands, but at least they're providing a little bit of detail to how it might be calculated. And then in this one, you'll see that it'll only be adjusted if it's above or below a certain dollar amount, but then it would be on a dollar-for-dollar basis. This next example is very shorthanded. It just says it's anticipated to be based on an average net working capital for the last 6 months. That leaves a little wiggle room about how it's actually going to be calculated. And this example also shows that you can do the adjustment, adding or subtracting to seller notes. That can be a good tool. Buyers don't want to have to provide more cash 30 or 60 days later, and sellers don't want to pay the buyer cash, they don't want to pay them back. So instead of having an escrow or some other mechanism to pay back, or using the seller notes if they're already part of the transaction could be a good tool for that.
Another area of purchase price adjustments is the whole topic of earnouts. And earnouts are something that if you're going to have it as part of the transaction, you definitely want to mention it in the letter of intent because it's a very important part of the purchase price. Let me back up for just a second and describe a situation where an earnout may come up. Typical negotiation for one that might end up with an earnout would be something where the seller comes to you and says, okay, I want $20 million for my business. The buyer comes in and says, hi, I'm willing to pay 10. You've got an obvious difference there, but the parties decide that even though there's a difference in price, it's a good fit otherwise, and they want to find a way to make it work. It may be that the buyer is willing to pay more if the business does well post-acquisition. Also, let's assume in this particular situation, the buyer knows that they need the seller to remain active and involved in the business for a period of several years after the deal closes. This is the perfect situation for an earnout. The parties could agree in this example to pay a base purchase price of $10 million at closing. They could agree to some percentage of new revenues being payable as an addition to the purchase price for the 3 years following the closing. And perhaps in this case, the total could be capped at $10 million if that's the price that the seller is willing to accept as a top end. So this additional payment that we're talking about is what's referred to as an earnout, and it is in effect a contingent purchase price. As you would expect, earnouts are a frequent topic of disputes, and we'll touch on this when we talk about cases later in the presentation. The reasons up for it are pretty obvious. First of all, it's much easier if you're the buyer to think that maybe after you've got the business, it isn't such a good idea to pay more for it. Second, there can be disputes over just the basic method of calculation. Third, anytime you have an earnout, even if it's detailed in the agreement that is finally signed, there's a risk that some level of detail will be left to future decision, and that can lead to disputes. Obviously, the earnout is not going to be described in huge detail in the letter of intent, but there are some topics that should be covered, and those are basically the percentage that's going to be used for the calculation of the earnout, the duration, the period it's going to cover, what metric is going to be the basis for calculating the earnout, is there a tracking or reporting requirement, and if so, what's the timing and what's the content. Typically, this doesn't get into a letter of intent, but it may be important to consider whether you need to state where the obligation to pay the earnout will stand as opposed to other obligations of the buyer, for example, secured creditors. And then another area that can be really important is to consider whether there should be early payment triggers for the earnout. That leads right into a question of control. In any earnout, you need to think about, if you're representing the seller, whether there is an adequate mechanism in place for the seller to be assured that they're going to have the ability to run or control the business post-closing in a way that makes it possible to achieve the earnout. What input is the seller going to have during the earnout period? Are there some transactions that may occur that would prevent the business from being run as it has been in the past? If so, then you may want to have an early payment trigger. And at a minimum, in the letter of intent, you may want to say that the definitive agreement will include provisions on changes to the business that would require the seller's consent or early payment of the earnout. We have a couple of examples to show you for earnouts in letters of intent. This slide you see right now is a fairly typical earnout provision. It covers a percentage to be paid for the earnout. talks about duration, in this case 12 months. The metric here to be used for calculation of the earnout is gross profit. There is a cap on the earnout in this case. And I should point out that on this slide there is a typo. In about the middle line there it says to seller if 2000 XX gross profit is equal to or less than a dollar amount. That should be equal to or greater than. And then it also touches on reporting and tracking in a brief way, in that there's a statement that a report is due 120 days after the fiscal year end. There's an additional feature in this example that's useful. There's both an estimated and a final payment, so the earnout can be paid in stages. And this kind of an arrangement, first of all, again, is important to identify in the letter of intent if that's what the parties believe is best. Second, it can be used when the earnout period and the accounting period of the buyer may not be in sync. And so you may want to have an early payment based on an estimate and a final payment based on actually closing the books for the relevant fiscal period. Not covered in this example is anything about control or dispute resolution, which often is an extended part of the actual definitive agreement, or priority or security. Let's go to another example. This one takes a different approach. It is in a letter of intent that is much more general. There's a total amount stated, but that's really about all. Major items are left for agreement later. The milestones to be achieved are not specified. The metrics for the earnout really aren't talked about. It's not clear whether it's all or nothing, although there is a reference to the fact that the earnout may be payable on a sliding scale. So a lot is left to negotiation in this example. This one is clearly a much higher risk approach, but it might be acceptable if perhaps the earnout is not as significant a part of the purchase price. Maybe the parties have a long-standing good working relationship, or maybe this letter of intent is the best you can do because you're very early in negotiations. The parties want to put something in place, but they're really not in a position to agree on final formulas. This example is obviously much more likely to end up in court if the parties don't reach a definitive agreement and end up litigating over the letter of intent. Let's talk now about escrows.
Escrows and holdbacks are another type of purchase price adjustment. It means they're going to hold back a portion of the purchase price or put with an escrow agent for a certain period of time a portion of the purchase price. When considering whether to use one of these mechanisms or when it's appropriate to use them, things to think about are the seller and buyer in disagreement about what the actual purchase price of the company should be. This tool can help bridge the gap between differing views on valuation of the company. If the buyer has some concerns about certain risks, this is a risk allocation tool. It could assure them that they have access to indemnification payments for a period of time after closing without having to go hunt down shareholders or a company that could have been dissolved. It can thinking about it would be timing of payment. You have to think through those things and whether it's going to be over a year, 2 years. I've seen them longer, and then how is it going to be paid back or paid to the seller? If the buyer is expecting an escrow or holdback, it should be in the LOI. It would be really difficult to get a seller to agree to this later in the process. And it's helpful for a buyer to think through areas of concern. Diligence at this point is not likely complete, but buyer may have an understanding of certain areas of risk. Is there pending litigation? Is this company a potential target for environmental issues? Are there depending on the type of transaction, is there employment liability risk that they're taking on? So they might have an idea of areas of risk and that would be a helpful negotiation tool for the buyer to get one of these in the LOI. If a buyer is going to require one of these, a seller could then use it to negotiate a cap on their liability. I think Eric has a comment on this.
Yeah, I do have a thought on this one. This ties back a little bit to the notes that Megan was talking about earlier under purchase price. One combination that you can use very successfully in place of a cash escrow in the right circumstances is to have the LOI provide for an indemnity note. And this can be both a way to provide something of an escrow and also let the seller basically have a lower financing need. Obviously, the buyer. Obviously, the seller needs to be comfortable with this, but in a transaction that we closed recently, basically 80% of the purchase price was payable at closing. 20% was going to be in the form of a 2-year note that would be paid only after deducting any indemnity claims that came up during that period. So the note served, in essence, as a substitute for escrow, and that can be a handy feature to include in a letter of intent when the circumstances are right.
Other frequently used provisions in an LOI relate to employment or consulting. These tend to be very deal specific, and in some cases, it is really important to a seller, despite the fact that they're selling their business, that their current employees be protected, that they're going to continue on in the business for some, that they're going to be offered employment and not just laid off and as part of the transaction. In this case, a seller would require something like, buyer's gonna hire or offer employment to all current employees. And a buyer in this case might insist on not being obligated to retain employees for an indefinite period of time. You wouldn't want the LOI to serve as some sort of employment agreement or obligation on the part of the buyer. A buyer may also have to consider whether the transaction is going to result in duplicative employees and having to fire certain people or lay them off. And from buyer's perspective, this could, having to hire employees or deal with those types of issues could also lead to more time and diligence. And depending on the structure of the deal, they might have to investigate more employment liability issues or employee benefits issues. The parties may also have to adjust the price because who's going to pay if they're transitioning, so if it's an asset deal but they're still having to hire or offer employment to all these employees, who's going to pay their paid time off, the accrued paid time off, or if people are going to be laid off, who's going to pay their severance and COBRA? What is that going to look like? From a buyer's perspective, they may want to make, as part of their transaction, key employees staying on or signing an employment agreement with them. They may not know who those key employees are yet, but they can still include in the LOI a closing condition that, key personnel as determined by buyer will execute employment agreements with buyer as part of the closing. And related to key individuals or consulting services, where maybe the buyer doesn't need them to be a full-time employee, but there's certain key individuals, a founder, a retiring, or potentially retiring CEO who has been with the business for a long time. Every employee knows them. They'd provide to help provide a smooth transition. They'd be a familiar face around the office as they transition to a new owner. The buyer may require that those individuals sign a consulting agreement as a closing condition, and that those types of things should be in the LOI because without them they'd be difficult to negotiate later. One
very important provision that comes under the topic of employment consulting and services is a non-competition or non-solicitation provision. This is something that definitely should go into a letter of intent if it's important for the buyer, and typically the buyer is the party that's going to want to have these provisions in place. There are two different levels to consider when you're looking at non-competition or non-solicitation clauses, and those levels are the shareholder level and the employee level. For the shareholders, it's very likely that some of them, those who are involved in the business, will know the business very well. And the motivation for a selling shareholder to turn around later and compete is there, and it's very real. We've seen it many times. You will have a individual come in, new client, and he or she says, I'd like to start a new company. And we talk to them, and it turns out that the reason they're starting the new company is they had a successful business several years ago, they sold it, they had a non-compete, the non-compete expired, they're ready to go again, and they jump right in and start a new business. That may happen for a number of reasons. It may happen because the buyer may have taken the direction the company in a direction that the client thinks is unwise or unprofitable or uncompetitive, and the client may see an opportunity to jump back in. Usually, our conversations with these clients indicate that the non-competition clause has actually done its job. They typically approach us either shortly before or right after the non-competition clause expires. So although this dynamic is out there, I think it underscores both the need for and the typical effectiveness of including these clauses in the letter of intent so that they can be part of an agreement. It's also important to address non-competition as to key employees who are not shareholders. They may not have the same motivation to start their own business, although they could. But a non-competition or non-solicitation clause can encourage them basically not to jump ship under the buyer's direction. And if the buyer needs them, that can be very important. If you're going to include a non-competition or non-solicitation clause in your letter of intent and ultimately in the deal documents, it's critical to take into account state law restrictions. This is one of the few areas that really you do have to look to outside sources of law when deciding how you're going to draft the letter of intent. And where you are matters a lot, or where the buyer and seller are matters a lot. When you're dealing with shareholders, these two levels that we've talked about have different effects under state law. When you're dealing with shareholders, you still have broad discretion as to the scope of business, geographic coverage, and duration of a non-competition clause. But with employees, that's often not the case. As an example, you can't impose a non-competition clause at all in some major markets such as California. And when you can impose them, state law sometimes limits the extent of the clause that will be enforced. For example, Oregon just changed its law in the last couple of years to move the non-competition period that was allowable from 2 years to 18 months. Those are the kinds of things that you need to take into account when you're drafting a letter of intent. One mistake that we see in this area fairly often, and this is usually when we're representing the seller, is the letter of intent may state that all key personnel are going to be required to enter new employment agreements with non-competition clauses in them with the buyer. The buyer needs to really think about that carefully before putting that in the letter of intent, and definitely before putting that into the deal documents. If you're advising the seller, you may say, look, fine, go ahead and agree to that, because what they're going to end up doing is putting clauses into place that won't be enforceable under the applicable law. That can be the case if the states that are involved allow non-competition clauses, but only on certain events. For example, some states will only allow non-competition clauses to be entered in advance of or in connection with initial employment, or at the time of bona fide advancement. If you try to do that at the time of a deal, and there's no new employment going on, then the buyer can end up shooting themselves in the foot just because they wanted to have a different form or a new form of contract in place. So it's something to be particularly careful about. One last comment on this area. There's a big difference between non-solicitation and non-competition. State law restrictions generally are much looser or don't apply to non-solicitation clauses. Another area that's important under the employment topic and can come up in the letter of intent negotiation is any kind of clause where there's a union shop involved. If the seller has a collective bargaining agreement, then there are considerations that need to be considered by the buyer before going forward with the letter of intent. Seller also has some considerations to take into account, but both parties need to know whether the buyer is going to assume the union contracts. If the buyer doesn't intend to, then the seller may find that he or she has some liability under that contract, and it can be significant. The buyer may want to hire some but not all employees. The buyer needs to know that under labor laws, if there is a collective bargaining agreement in place and they hire more than 50% of the existing workforce, then they must negotiate with the union as to that contract. There can also be collective bargaining agreements that require by their terms, not because of applicable law, but under the terms of the agreement, that the seller require the buyer to assume the contract in any acquisition of the business. This is not an unusual clause, and it's one of the things that the buyer needs to be aware of in a business transaction. Another area that's important in the union area, and well, particularly in the union area, is benefit plan withdrawal liability. You want to find out if you're a buyer, whether your seller is subject to a multi-employer pension plan. If they are, any change in participation in that plan, at least a change that is considered this equivalent to withdrawal, can result in very large liability. And these are big numbers. We recently were advising a client on a situation where there may be a withdrawal intended, and the calculations showed that the withdrawal liability could be greater than the value of the entire company. So this is a really important area to look at if you're seeing that there is a collective bargaining agreement involved or a multi-employer pension plan. One other area, and this really applies both union and non-union, is whether or not you're going to have a WARN Act obligation. Typically, if you're dealing with parties where there are fewer than 100 employees total, and you're hiring, more than 100 total, and you're laying off more than 50, then there will be a need to take into account the WARN Act. WARN Act requires 60 days notice or sometimes pay in lieu of notice. Again, from the buyer's standpoint, that's going to be very important. On all of these considerations, I would say that if you see these topics coming up when you're drafting a letter of intent, it's a good idea to talk to a labor attorney and get advice on where the liabilities might stand and how that should be dealt with in the letter of intent.
Next, we're going to talk about provisions in the LOI that relate to the definitive agreement. Most LOIs will have a paragraph that states the definitive agreement will include typical and customary terms. Those customary terms include representations, warranties, covenants, conditions, and indemnification. Sometimes a little bit more detail than that is needed or recommended. What is typical and customary? If you have a unique industry or a complicated deal, you might not actually know what is customary in those scenarios. You might also want to make sure that certain ones are mutual. So you should really think about whether more detail is needed to explain what the parties agree. agree to, especially if it's a complicated transaction or a unique industry, or one where, maybe every deal is different, and so there is no real customary term for those types of reps, warranties, covenants, etc. You may want them, to detail out if the reps and warranties should be mutual, if there's going to be a merger, or maybe where consideration is paid part in stock or mostly in stock, because the sellers are going to have certain concerns too about the buying company or the surviving company. Some typical and customary terms are capitalization of the company, authority, no conflict. Those are often in every agreement, but there's other ones, that they may need, depending on what type of business it is, and so you should really think through, give it some thought what other ones you might want in there so that there's no surprises later. Of course, the parties have not done a lot of diligence at this stage, but you should really, if there is going to be indemnification in the agreement, which again most often there is, the LOI should at least reference that there will be indemnity. If you don't include that in the LOI, it may be difficult to negotiate later. And Eric will talk a little bit more about indemnification in a couple of slides from now. The LOI should also state what will survive termination or expiration of the LOI in the event the definitive agreement is never executed. There's certain types of provisions that should always survive, and that, like confidentiality and those types of things. And then lastly, what's often included is who will prepare the definitive agreement. That should be in there so that all the parties' expectations are aligned, and typically it's the buyer that prepares it. And sometimes even they put in a timeline that it'll be prepared within X number of days, or an initial draft will be given by X date. You can include those types of provisions at this point too. Now we're going to talk about just a couple of examples of what we see in LOIs. In this example, you'll see there's no specifics about reps and warranties, covenants. It just says provisions customary in transactions of a similar nature. And in this deal, that might have been very easy. It's a small asset deal. It may be very easy to figure out what those are, but in other circumstances that might not be appropriate. Another typical provision is that's often included when talking about definitive agreements is that the letter of intent is non-binding and is expressly subject to mutual due diligence and negotiation and execution of a legally binding stock purchase agreement and related agreements.